Welcome to Hybiz News. I am Amalu Katragadda. Despite RERA, home buyers can pursue remedies against real estate firms at consumer forums. In a significant verdict, the Supreme Court on Monday held that despite the enactment of a special 2016 law, RERA, to deal with real estate firms, home buyers can still approach the consumer forum to seek remedies including refund and compensation from such companies for delay in handing over possession of their dream homes. The top court rejected the contention of real estate firm Imperia Structures Ltd that once the Real Estate Regulation and Development Act RERA came into force, all questions relating to construction and completion have to be dealt with under this law, and the National Consumer Disputes Redressal Commission NCDRC ought not to have entertained the consumers' complaints. Dealing with various provisions of the RERA and the Consumer Protection Act, a bench of justices Lalit and Vineet Saran referred to various judgments and said it has been held that though the proceedings before the NCDRC are judicial proceedings, the Commission at the same time is not a civil court within the meaning of the provisions of the Code of Civil Procedure. It may have all the trappings of the civil court, but yet it cannot be called a civil court. On the strength of the law so declared, Section 79 of the RERA Act does not in any way bar the consumer, commission or forum under the provisions of the CP Act to entertain any complaint, Justice Lalit said in the 45-page judgment. After the enactment of RERA, real estate firms have been taking stands that the consumer forum have no right to deal with the complaints of home buyers against them. The apex court settled the issue and said, though the special 2016 legislation has many features to the advantage of home buyers, still the consumer forum have the authority to keep entertaining the complaints of home buyers if they fall under the definition of consumer under the law. The RERA does not statutorily force a person to withdraw any such complaint, nor do the provisions of the RERA Act create any mechanism for transfer of such pending proceedings to authorities under the RERA Act, the judgment said. Again, insofar as cases where such proceedings under the CP Act are initiated after the provisions of the RERA Act came into force, there is nothing in the RERA Act which bars such initiation. The absence of bar under Section 79 to the initiation of proceedings before a forum which cannot be called a civil court and express saving under Section 88 of the RERA Act make the position quite clear. Thus, the parliamentary intent is clear that a choice or discretion is given to the allottee whether he wishes to initiate appropriate proceedings under the CP Act or file an application under the RERA Act, it said. Thanks for watching Hybiz News.